The Subcommittee on Capital Markets will come to order. Without objection, the Chair is authorized to declare recess of the committee at any time. This hearing is entitled Oversight of the SEC's Division of Investment Management. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the Chair for inclusion for the record. I now recognize myself for 5 minutes to give an opening statement as soon as Mr. Gottheimer comes to order. Thank you. Thank you for joining us today. This hearing will examine the actions taken by the SEC's Division of Investment Management under Director William Birdthistle's leadership that have comprised the Commission's mission to protect investors, maintain fair markets, and facilitate capital formation. This is our 3rd oversight hearing and our 4th SEC Division Director that has come before the committee this year as part of our effort to hold Chair Gensler's SEC accountable for its overly burdensome, sweeping, new regulatory regime that will affect every single corner of the financial services industry. The Division of Investment Management has broad regulatory responsibility over registered investment companies, investment advisors, asset managers, and other entities that manage money on behalf of millions of Americans. The paternalistic regulations coming out of this division undermine the financial goals of millions of American families relying on strong financial returns for their retirement. Since spring of 2021, the SEC has proposed over 50 rulemakings without a thorough evaluation of their cumulative effects. This approach threatens financial market stability and imposes undue burdens on participants and investors. The SEC has not done its homework, and it only underscores the importance of comprehensive cost-benefit analysis, not cut and paste. The SEC has hastily rolled out a series of interconnected rule proposals in a span of just 2.5 years, jeopardizing the integrity of our capital markets and putting investors, especially those saving for retirement, at undue risk. Instead of diligently analyzing how these proposals will impact one another, the Commission is neglecting its duty to protect investors and ensure fair markets. This rushed approach reveals a flawed understanding of the markets and the participants it aims to regulate and relies on speculative statements rather than concrete evidence. The complexity of these proposals not only deters public input, but also risks causing chaos in the capital markets through overlapping and conflicting rules. And when market participants do offer their input, the SEC has repeatedly disregarded their valuable insights. Short or inadequate comment periods limit feedback, contradicting rulemaking process requirements. Ensuring the public's voices are heard is crucial, and the SEC must encourage robust input and analysis. Furthermore, the SEC's reluctance to consider congressional views is also deeply concerning. For example, the SEC's refusal to extend the relief provided in its 2019 MiFID no action letter disregards bipartisan congressional requests for an extension and a market impact assessment. I'd like to remind the Director that the House directed the SEC to extend its no-action letter relief by passing H.R. 2622, which passed unanimously, in addition to sending several bipartisan letters from this committee and our colleagues in the Senate. The SEC's decision to ignore calls for relief erodes U.S. markets, their competitiveness, and endangers access to essential research services for buy-side managers. Lastly, specific proposals like swing pricing, hard close, and liquidity risk management have raised alarms. If adopted, these proposals would create investor confusion and weaken the financial returns of over 100 million Americans currently invested in mutual funds that they've experienced it for decades. These proposals lack a solid evidentiary foundation and rigorous analysis, raising questions about their alignment with the SEC's mandate to protect investors and maintain fair markets. I share similar concerns with the SEC's recent proposal on predictive data analytics. The proposal's burdensome one-size-fits-all approach will limit investor choice and access, increase costs for retail investors, and lead to a decline in retail investor participation right when it has reached an all-time high. The SEC's regulations should be technology neutral to promote innovation and efficiency in capital markets. If the SEC intends to be a technology regulator, it should seek explicit authority from Congress. Throughout this hearing, we will address these pressing issues and seek answers from the SEC's Division of Investment Management. Ensuring the SEC's rulemaking process is transparent, accountable, and serves the best interest of American investors and financial markets is our priority. I want to thank you for your attention, and I look forward to a productive discussion today. The chair now recognizes the ranking member of the Subcommittee on Capital Markets, the gentleman from California, Mr. Sherman, for 4 minutes for an opening statement.
And I would ask that the ranking member of the full committee be able to give her 1 minute when she arrives,
Without
whether
objection.
that before or after the witness testimony. Sat here in some crypto hearings and other hearings where people say we need to have, we don't want to have regulation through enforcement. Your division does regulation through regulation. You should be praised. I hear in those hearings how we need clarity. You're working hard to provide that clarity. I read in Bloomberg that you're actually putting forth fewer regulations than your predecessor. So work harder. And we're told that the process is criticized. Almost everyone who criticizes the process simply doesn't want you to get to the destination. It's not the road. Your division has done two things I want to talk about. One is you've put on a level playing field investors in these private funds. In doing so, you've taken away the advantage that, say, CalPERS, the biggest, would have over, say, Wyoming. That is a very bad thing. California should always be advantaged, and fairness is whatever gives California an unfair advantage. But if I was from another state, I would say congratulations on that. And second, you've got the streamlined summary reports for those investing in mutual funds. I've used those myself. Thank you. So while I generally approve of what your division is doing, I do need, along with the chair of this subcommittee, to talk to you about the swing pricing rule. Now, swing pricing rule is focused on the idea that maybe if people think the ship has hit an iceberg, they'll want to get on lifeboats. We want to discourage them from getting on lifeboats. First, if people think the ship has hit an iceberg, imposing a fee on them to get on the lifeboats is going to make them really want to get on the lifeboats. But we have a system under swing pricing where if you're a very large investor and you don't need a mutual fund, you have your own private lifeboat, no charge. That is to say, if you're a big investor, you don't need a mutual fund. You just create a mirror portfolio. If you're a institutional investor and you're in the CIT, you're not subject to this rule. That is collective investment trusts. So you get on a lifeboat for free. The only people who have to pay for the lifeboat are the people who are on the ship in second-class steerage. That is a bad way to deal with, it's simply unfair to say that if people want to sell their mutual funds at a time when they think they've got to sell, even if they're spooked, that you charge them a fee for doing so. There may be a role for this swing pricing rule in some very narrow, relatively illiquid funds. But when you look across the board, I join with the chairwoman in urging you to substantially modify or abandon this. You also have the hard stop is necessary to implement it. That disadvantages Californians, and you already know how I feel about that. It disadvantages everyone in the Pacific time zone, even those from lesser states in the Pacific time zone. And then your definition of illiquid assets, I think, could be a problem in a number of ways, not only for the markets, but also for those dealing with apartment loans, and the number one concern of my district is homelessness and the fact that rents are too damn high, and that's a matter of supply and demand. So 36 of our colleagues, including the vast majority of Democrats on this subcommittee, have written you on swing pricing. Keep doing a good job. Part of a good job is to stop doing that. Yield back.
Today, we welcome the testimony of William Birdthistle. Director Birdthistle is the Director of the Division of Investment Management at the SEC. We thank you, sir, for taking the time to be here, and without objection, your written statement will be made part of the record. Director Birdthistle, you are now recognized for 5 minutes to give your testimony.
Thank you. Chairman Wagner, Ranking Member Sherman, and members of the subcommittee, thank you for your invitation to testify today about the activities and responsibilities of the Division of Investment Management of the Securities and Exchange Commission. It's my honor and pleasure to appear before you today to discuss the division's work. I am testifying today in my official capacity as the Director of the Division of Investment Management, but my testimony does not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I have served as the Director of the Division since December of 2021, and I am deeply proud to work alongside a staff of such dedicated public servants on behalf of the American investing public. The Division has primary responsibility for administering the Investment Company Act of 1940 and the Investment Advisors Act of 1940. Collectively, those acts regulate investment companies, such as mutual funds and exchange-traded funds, as well as investment advisors, including advisors to registered investment companies and, in certain cases, to private funds. The work of the Division of Investment Management is vitally important because it directly impacts the lives of many Main Street American retail investors. The financial instruments that the Division oversees include some of the most common investments that millions of Americans use to help secure their financial futures in order to buy a home, to send their children to college, or to prepare for their retirement. The Division's role has grown increasingly important in recent years as the industry it regulates has experienced all-time highs in its growth and development. Over the past 10 years alone, the assets managed in SEC-registered funds have increased nearly 96%, from less than $15 trillion to nearly $29 trillion. As of last year, more than half of American households, 54.7%, and more than 115 million US individuals owned registered funds. Similarly, the gross assets of private equity, hedge, venture capital, and similar funds have grown 150% to over $25 trillion over the last 10 years. Moreover, the number of investment advisors registered with the SEC now stands at more than 15,000, serving more than 60 million clients, which represents an all-time high for the industry. Approximately 220 civil servants are in our division across 5 offices, and they work to oversee this legal framework and the more than $114 trillion in regulatory assets under management that it covers. Staff throughout the division discharge their responsibilities dutifully and with great care, as we know that these dollars comprise the earnings and investments of millions of American citizens saving for their families' futures. The division's 5 offices diligently work in concert to ensure that we are executing the SEC's mission and protecting the millions of Americans who have chosen to invest in funds of all varieties. Indeed, the most recent results of the Partnership for Public Services survey of best places to work in federal government ranked our division 3rd out of 422 agency subcomponents. That is above the 99th percentile in the category of performance. Thank you again for your invitation to discuss the division's work. If I may conclude on a personal note, I experienced the great joy and enormous privilege of becoming a United States citizen 15 years ago. And my 20 months at the SEC have been the greatest honor of my professional career. I am particularly grateful for the opportunity to serve with extraordinarily dedicated members of the Division of Investment Management. Those public servants are fully committed to serving their country and to our mission of promoting the formation of capital, preserving market integrity, and protecting the treasure of our fellow Americans. I'm happy to answer your questions.
Thank you, Director. We'll now turn to member questions, and I recognize myself for 5 minutes for questioning. Director Birdthistle, the SEC has received almost 3,000 comment letters in opposition to swing pricing, hard close, and liquidity risk management proposal. It's worth noting that this opposition spans the political spectrum, with organizations like Better Markets, the Consumer Federation of America, and the U.S. Chamber of Commerce expressing their concerns. Even the College Savings Foundation opposes the proposal. Both Republicans and Democrats on this committee, including myself and the ranking member Sherman, have written the SEC multiple times expressing their opposition to the proposed rule. Given these facts, are you willing today, sir, at this hearing to pledge to withdraw this rule as written? And if not, why not?
Swing pricing has certainly received an enormous amount of comments, as you suggested, Madam Chair, including your letters of September 5th with Ranking Member Sherman and from earlier.
Are you willing to withdraw the rule, sir?
I don't speak for the Commission, Chairman, so I'm not in a position to make a decision like that.
If not, why not? What have you taken into account? What is your takeaway after all of this?
Certainly that it's a complex dynamic and that we need to give it the full attention that your comments and your letters and your concerns here warrant, and we've been doing that. The staff and I work very closely through the comment period and beyond to consider your concerns, to look for alterations or other ways in which the rule could be adjusted at adoption.
Would like the rule withdrawn as written. Director Birdthistle, in your recently proposed rule on open-end fund liquidity, you make significant changes to the liquidity risk management provision of mutual funds. One of the most concerning aspects of the proposal involves categorizing a wide range of assets as illiquid, including bank loans, which consequently subjects them to a maximum allocation of 15% within a fund. Many industry stakeholders have commented that your changes to fund liquidity would restrict investment strategies that are available for retail investors through mutual funds, particularly retirement savers. Was that your intent when proposing this rule?
Madam Chair, the open-end fund liquidity rule exists to ensure that when investors wish to take their money out of a mutual fund, that money will be available. A challenge from bank loan funds is that that industry settles their deals in a matter of weeks, which is a challenge to a regime that needs to have the money on hand more quickly. So that's a concern with bank loan funds, but it's a decision that that industry can adjust if they had a shorter settlement period.
You know, you may say, and oftentimes it has been said that this rule is about systemic risk, but even in the market volatility we saw in March of 2020 due to a historic worldwide pandemic, no mutual funds failed. I underscore, no mutual funds failed. And no facility at the Federal Reserve was created specifically for mutual funds. In my mind, these events would show the resilience, not the weakness, of mutual funds. This leads back to my original question. Considering no mutual funds failed in 2020, March of 2020, do you believe limiting investment strategies for Americans' retirement savers and retail investors is the appropriate response to these events, yes or no?
What we're attempting to do with the adoption and the proposal of this rule, Chairman, is to ensure that in future instances where the events of March of 2020 could be more prolonged, they could be worse than that event, or there might be an incident.
Nothing happened. No Fed facility was set up.
There was a Federal Reserve liquidity facility for money market funds, but correct, there
It was
not.
never tapped.
Certainly. So again, our hope is to ensure that that is always going to be true for open-end funds, so that any investor.
A solution, sir, in search of a problem. Director Birdthistle, the SEC's proposed rule mandating open-ended funds to implement swing pricing and a 4 p.m. hard close mentions various costs that could be imposed on investors. The potential drawbacks include decreased portfolio returns, reduced investment choices, inefficient portfolio allocation, and exposure to additional market risks. In contrast, the proposal theorizes that some benefits may come from the rule, including reducing the so-called first mover advantage. Because current law and regulation require an economic analysis of proposed rules to be included upon release, please tell us, what is the overall cost to retirement savers from the open-end fund rule? What would it be?
The costs and benefits are contained in the 130-page economic analysis.
It's one paragraph, this long.
The economic analysis is 130 pages. It's produced by our colleagues in the Division of Economic and Risk Analysis. But this is a proposal, so that economic analysis can and should be updated as we move forward.
I have many more questions, but I am out of time. Thus, I will turn to the ranking member for 5 minutes. We'll go to Mr. Vargas. To Mr. Vargas for his questions for 5 minutes as soon as he is ready.
I'm ready.
Good, there we go. You're
Coffee
recognized.
makes me ready because I don't normally drink it.
You're
I'm
recognized.
very ready. First of all, thank you very much, Madam Chair, and the ranking member for this important hearing. First question I'd like to ask the Director Birdthistle is, I heard that there were lesser states in the Pacific time zone than California. Which ones are they? I'm kidding. I do want to ask you this. I assume that you read the newspapers
I do, sir.
and the headlines and the rest. Could you tell me what Allstate is doing in states like California and Florida? Because I'm sure you've read the headlines. The headlines have been all over the place.
Our jurisdiction just covers investment funds, Congressman.
Well, then you should be following it, because if you invest in Allstate or these large insurance companies, you would know that they're moving away, or they're not, many of them are moving away, and many are not renewing policies or not taking on new policies in California and in Florida. Do you know why?
I believe it has something to do with their assessment of insurance risk, but that's
That's right. It is because their assessment of insurance risk. And what is the risk in particular? Do you know that they're not only cautious about, but they've seen results? Do you know what that danger is, that risk is that they do not want to insure?
I would prefer to confine my remarks to our area of jurisdiction, if I may, Congressman.
Well, I think it does, because if you read these articles, you'll see it's climate change. In California, the significant number now and the intensity of fires. In Florida, you'll see that it's the weather. I was in the insurance business for a while, and there's something called a catastrophe, or a CAT. We used to call them CATs. There were 100-year CATs, 50-year CATs, 25-year CATs. What that meant that these catastrophes were supposed to happen every 100 years, 50 years, 25 years, or 5 years. These 100-year CATs now are happening every 5 years. This is not normal. And it's not normal, all the scientists say, because the climate is changing. The environment is changing. And that's why these large insurance companies that are not in the business of losing money, they're in the business of making money, do not want to insure in these areas. Now, a lot of people are angry about this, and they should be, but the reality is they're not in the business of losing money. So the reason I say that, if I'm a reasonable investor, and I am investing in Allstate or a large insurance company, would I want to know about those environmental risks?
Sir, I believe you may be alluding to a proposed rulemaking being conducted by my colleagues in the Division of Corporation Finance, which relates to climate, and I would defer to them on that rulemaking.
Well, but you're here in front of me. That's why I'm picking on you. Now that you're a citizen, you can answer these questions. But if I'm a reasonable investor, would that be important to me?
Well, sir, what we do in the Division of Investment Management is attempt to encourage the creation of disclosure so that investors can make their best decisions in their own interest.
That's right. And these disclosures would be very important for me. I'd want to know these things. And that not only, the footprint, the carbon footprint of the company, but also, very importantly, how is climate change going to affect that company? Especially if my investment is a long-term investment. I'd want to know that. And that's why I think it's very important to have these disclosures. I think it's very, very important. I think it's material. What happened was, when they were trying to define what is material, the Supreme Court, the great Thurgood Marshall, took the reasonable standard, the objective standard, out of torts and put it into the SEC and said, what would the reasonable man, but now it's the reasonable person, as it should have been, the reasonable person, what would he or she want to know before they make decisions? I would want to know this information. Now, we find out that lots of investors want to know this information. They're asking for this information. That's why this information should be available to them. And again, I thank you, and not necessarily your division, but the SEC for moving forward with this. I think it's very important. I mean, if you do read the newspapers, you'll see that it's splashed all over the headlines all the time now. I mean, I could read you some here, but I don't want to bore you to death. But, it's stuff like, even as climate change worsens, military eyes the base of the future on the Gulf Coast. The military is concerned about this. We take a look and it says, falsehoods follow close behind this summer's natural disasters. Why? Because the scientists tell us it's climate change. That's why these disclosures are so important. I hope you guys continue. I think you're on the right path. Keep going forward. And I appreciate your work. Thank you. Congratulations on your citizenship. It is the greatest country in the world, the United States of America. Thank you.
Thank you, sir.
Gentleman yields back. The chair now recognizes the gentleman from Arkansas, Mr. Hill, the chairman of the Subcommittee on Digital Assets, for 5 minutes.
Thank you, Madam Chair. Thank you, Congressman Sherman, for holding this hearing. Director, good to be with you today. For basically 26 years of my 4-decade career, I've spent it in the broker-dealer and registered investment management business. And so I want to talk first about this predictive analytics rule that the Commission's proposing. It seems to be so broad to me in terms of covered technology, and I know you had some things that were not included. I read the release. And investor interaction is encompassing every single considered interaction between a registered broker-dealer and advisor and every other tool and technology with investors. So I think it's a tough rule to try to comply with. As it's currently drafted, in my opinion, it's not just AI and machine learning, which I think is at the heart of what you're trying to get at, but it includes even the basic math functions of an Excel spreadsheet that might be predictive in some way. And the proposal provides any evidence of actual abuse involving this technology. So the scope is unquestionably broad, and it would require broker-dealers and investment advisors to eliminate or neutralize conflicts of interest that arise when they use a covered technology. So I think it's tough. And I think complying with these rules is always challenging, but this one's particularly broad. Can you give us a couple of specific examples of what the SEC would not consider covered technology?
Certainly, sir, and thank you very much for your close attention to it. Your emphasis on scope, I think, is a fair one. We will and have been getting comments on this release. It's just a proposal currently, and the comment period is open through October 10th. And scope is an area of focus. Again, the aim of the rule as proposed is to ensure that investment advisors don't use those sorts of technologies that you mentioned, machine learning, artificial intelligence, predictive data analytics, to put their own interests ahead of their clients. So again, any technology in which that wasn't the case.
But isn't that already against the rules? I would say against the law, but I won't say that. Isn't that already against FINRA and SEC rules and rules of conduct now? Yeah, the answer is yeah, it is. So there's no difference between what they do in an analog world that's against the rules and something that might be use of technology. So let me keep moving. I think this could discourage firms from using cutting-edge technology solutions that might save on costs, that might otherwise be passed on to investors. So I look forward to the comments. I think it's too broad. You say that, for example, something you don't include is it wouldn't affect being approved for a corporate credit card. I mean, come on, this is ridiculous. Let me switch subjects, Director. You also have a rule talking about custody, which is a big rule that Chairman Gensler's going to be hearing about, I'm sure, when he comes up and testifies. I want to talk about the non-crypto aspect of that rule, because when I read it, it appears to me, again, it goes against common law. It goes against very traditions of commercial banking and trust banking rules of what is custody. And so I want to ask you, what did the SEC staff do in talking to the prudential bank regulators before they proposed this rule? Did you have those meetings?
Yes, sir. We, as a matter of regular course, we meet with other financial regulators on any areas of common jurisdiction.
Could you share with us, if we sent you a letter and asked for the details on that, would you share it with us, like a share of emails or when those meetings were taking place and when they were, who came to those meetings?
I would have to defer to our Office of General Counsel for a ruling on that kind of a request, Congressman, but my staff and I are very happy to cooperate with you and your staff.
Yeah, I think it's, again, Madam Chair, I think we know this, it is not tradition that you put up cash against the value of something held in custody for a client. That's the exact opposite of custody, and that's the direction that Chairman Gensler has gone for digital assets, which I desperately disagree with, but he's extended it beyond that. And I think it really is disruptive to something that works quite well in America, which is safekeeping and custody rules that are very common. So we will follow up with you on writing on that, Director. I want to thank you for being before us today, and I will yield back to the Chair.
Thank you, sir.
Gentleman yields back. The chair recognizes the gentleman from California, Mr. Sherman, the ranking member of the Subcommittee on Capital Markets, for 5 minutes.
I share Mr. Hill's concern on these custody rules with regard to tangible assets. I think the mindset that went into drafting them was crypto and perhaps other intangible assets. How you would apply custody rules to real estate and whether you would have to put the real estate into a different title, I frankly haven't looked at, but I think you've got a rule that's designed for crypto and perhaps other intangible assets. Now, looking at swing pricing, Chairwoman asked whether you would withdraw the rule, and you pointed out that's above your pay grade. But I hope I can count on you to go back to the commission, say you came to this subcommittee, and you saw a unified, bipartisan, and well-reasoned commitment to get you to withdraw the rule. Can I count on you to do that?
Certainly, sir. We will, as a staff, share all of the learnings we have from a session such as today, the letters that you and the chair have furnished us with, as well as the comment file with the commissioners.
Now, a number of things underpin that. Of course, it's not just this committee where it's bipartisan. You've got business-oriented groups and liberal groups, both on this. The SEC has permitted swing pricing. Mutual funds are very competitive. They've got every different combination I can think of. And yet none of them, and correct me if I'm wrong, has chosen to go with swing pricing, which means none of them thought that there was any pool of investors out there that wanted to be in a fund that had swing pricing. Do you know of any fund that has gone with swing pricing voluntarily?
Sir, you're correct that in this jurisdiction, none has. In other jurisdictions where there is different plumbing, if you will, it has been used by funds.
This is a big enough country. It's we're talking about so many different mutual funds. You can invest in so many different combinations, and nobody has wanted that. I would point out that the Biden commission is absolutely dedicated to ending junk fees and surprise billing. When I put my money in a mutual fund, I buy it at net asset value. I complain a little bit that there's at least a management fee. And when I redeem, I expect to get net asset value. Now, my father, when he invested, there was a 5% load getting out. That was a really bad system. We haven't had that in any mutual fund I'm aware of. So it's a junk fee, it's a surprise fee, and it will have the effect of discouraging investment in mutual funds, which is the one thing we want people to do. We want the diversity. We want the investment in our economy. We don't want people investing in the number 6 on the roulette wheel, or worse yet, cryptocurrency. We don't want them picking 1 or 2 stocks. We want people to go to mutual funds. Am I correct that the large institutions and the wealthy can escape any swing pricing, either if they're banks investing in CITs, which are basically mutual funds but outside your jurisdiction, or if they're wealthy individuals, just constructing their own portfolio and staying out of mutual fund. Is that correct?
Sir, it's true that there are a number of other ways to gain exposure to the market. Our data shows that within open-end mutual funds, when there is a market stress occasion, typically the first movers are the institutional investors in that space, and they would be then asking the fund to sell the most liquid assets at that point, which leaves comparable.
One could imagine a swing pricing rule that applied to transactions of over $10 million, and you'd face an awful lot less opposition than when you start imposing swing pricing on the people that we represent. Is there any study that would indicate, I would say the best way to get people to pay $100 to get on the lifeboat is to announce that for the first time ever, you're charging people to get on the lifeboat. That would get me on the lifeboat, right? Is there any analysis that says that swing pricing will stabilize the markets, or would it have the effect of anything, of saying, oh my God, now I got to sell?
It's an excellent question, Congressman, and the economic analysis with this rule does take into account the costs and the benefits in an attempt to balance those considerations, as you suggested.
My time has expired. Thank you.
Thank you, sir.
Chair now recognizes the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
Thank you, Madam Chairwoman. Thank you, Director, for being here with us today. Thanks again to our chairs for continuing the series of an oversight of the increasingly brazen SEC. Director, I want to talk about the issues that have become more and more concerning, some of the conduct of the SEC under its current chair. Under this leadership, has been a lot of unpredictability, issuing rules that are pretty rapid, that neither the industry nor Congress can really keep up with, related to some of the extreme effects on the industry as a whole. So with the SEC churning out rulemaking at really an unprecedented rate, it appears to be overstepping in a few cases and delving into areas that fall outside the jurisdiction. Its behavior does leave our U.S. capital markets industry in a state of flux, guessing what the agency may do next. Specifically, I want to talk about the so-called safeguarding rule and predictive analytical rules that can be argued that are not only an overreach, but are harming investors and the market. So let me ask you this. The concern that the Commission is inserting itself into matters at the core of the banking system and squarely within the jurisdiction of the prudential regulators. Segregation of clients' cash having effects on monetary policy and bank recovery and resolution frameworks. Banks are subject to ongoing detailed supervisory oversight, as you know, including capital and liquidity stress testing and horizontal assessments of their operation. So the question is, with this occurring, as well as the Basel III endgame capital rules coming into play perhaps over the next year, if this actually goes through, is the Commission considering how such mandatory cash segregation, as proposed in your rule, coupled with the increase in deposit requirements, will impact risks at bank and risk to our economy?
Sir, yes, the staff in the Division of Investment Management has been meeting regularly with our prudential colleagues, the banking regulators, to consider all of those issues. This rule is a proposal currently, so we are in the moment where we can consider them. The comment period has actually been reopened through the end of October, so we are actively soliciting those and having those conversations with the banking regulators.
Okay, so you are talking with the Fed, you are talking with the regulators. Are you talking with the institutions as well, with the industry itself?
We certainly are. We have extensive meetings with trade associations as well as individual firms that have an interest in this space, large custodial banks, as well as other investment advisors who operate in this space.
Are you doing that yourself, your staff handling that? Do you have notes, perhaps, that you could share with us from these discussions?
I participate in many of those meetings. Our staff takes all of the meetings that are requested of us. Again, I would say that on a request for information, my staff and I would be very happy to work with you and your staff. I would have to defer to the Office of General Counsel on a specific document.
Sure. Is there anything that comes to mind where they shared a concern that altered or modified or improved your assessment of the situation? Perhaps an example you can share?
Well, generally speaking, we find a fair degree of sympathy when we have conversations about the overall goals of the proposal. So the proposal is to ensure that the assets that clients put with investment advisors are not stolen, lost, or misappropriated. And that's the guiding principle behind the safeguarding rule. On the specific components, as you suggested, sir, about its interaction with other components of the financial system, we're happy to take and are receiving extensive comments in that area.
Okay. Basel III, for instance, are there any that state that this is something that they think is a positive development and in their interests from their bank health as well as to their clients?
I'm sorry.
On the Basel III.
On the Basel III, our registrants are not directly subject to that banking regulation, so I would defer to financial regulators in the banking area specifically on a question with respect to Basel.
How about the safeguarding rule? You getting feedback there?
Yes, on the safeguarding rule, again, we have had extensive conversations about that with other financial regulators, but as you also said, with members of the industry, including trade associations.
Well, it's encouraging to hear that you are engaging a holistic view of all the stakeholders. And any information you can provide us on the outcome of those meetings and discussions would be helpful. I yield back, Madam Chair.
Thank you, sir.
Gentleman yields back. The chair now recognizes the gentleman from Illinois, Mr. Caston, for 5 minutes.
Thank you, Madam Chair, and thank you for being here, Director Birdthistle. On May 25th of last year, the Commission issued a proposed rule to expand Rule 35D1. This is the names rule. So you're nodding your head to prevent deceptive fund names that cover funds that suggest they invest in certain things, including but not limited to ESG. And I want to focus on the ESG piece of this. If I understand the rule, the proposed rule correctly, it says that if you have ESG in your name, you have to demonstrate that at least 80% of the assets you hold meet that test, subject to some exemptions. Can you comment at all on why the Commission felt that rule was necessary?
Yes, sir, and thank you for the question. So the names rule, as you suggested, is part of a core piece of the kind of disclosure that our division produces. Specifically, we ask funds to say what they intend to do, and then to do what they say. And in the namespace in particular, the funds can choose their own name, and they can choose their investment portfolio. The rule simply asks that the two correspond. With respect to ESG in particular, there's been a lot of growth in that space, and the rule hasn't been updated for about 20 years. So I think generally speaking, with this proposal, the staff was hoping to update the rule to take account of the growth in the area, take account of the fact that some funds using the same words might have slightly different intentions or meanings with them, to give them an opportunity to explain that to investors in their materials.
And do you have any sense of when that rule is likely to be finalized?
Tomorrow, sir.
Oh, really?
I can't speak for the Commission, and certainly not ahead of time, but the Commission did issue a sunshine notice a week ago that there will be an open commission tomorrow to adopt the names.
Oh, terrific. Okay, very timely. In that same vein, and this is maybe alluded to by your answer before, the Commission proposed another rule to address greenwashing in ESG funds, and I quite agree with you with the surge of, what are we up to, $8.5 trillion of investments in the space. Certainly appropriate to make sure it's not there. Did you have evidence going into that rule that firms were engaging in greenwashing? Is this sort of more a proactive measure, or were you trying to protect against some abuses that you'd seen in the market?
I believe, although I would defer to my colleagues in the divisions of enforcement and exams for specific instances, I think there may have been one or two that might have suggested that action here was worthwhile. But again, like the names rule, I think it's primarily a function of the fact that that space has expanded quite a bit, and that different players and parties in that space may use words in different ways. And by requesting clear and comparable information, it will allow investors to look across different kinds of funds to see whether or not they're making accurate and consistent investment decisions.
Well, I really want to thank you on both of them. As you know, Representative Vargas and I founded the Sustainable Investing Caucus, and it got sort of politically charged last month, but we really founded it because there's there's so much interest in this space, and there is a lot of confusion on exactly what things mean, and we appreciate the good work that you guys are doing to try to bring some standardization there. Just with a little bit of time left, I want to just also thank and commend the Commission for your focus on the digital engagement practices. I know this is still ongoing. I know there's been a lot of pushback from a lot of folks, but this is an issue, and I've spoken to Mr. Gensler about this. It's personal for me because, at least prior to redistricting, a former constituent of mine took his life at 20 years old because using the Robinhood app, they had, the note that he left said that he doesn't understand why a 20-year-old with $5,000 in his account was allowed to get $700,000 upside down on options trading. And there is a real problem with those apps. We had introduced the Trading is Not a Game Act to try to fix that last term. And obviously, you've got a lot of comments. I hope you'll take all those comments into account. But really, I want to thank you for doing it, for myself, for the Kearns family, and just encourage you to implement the strongest rule possible to make sure that we do protect the most vulnerable amongst us in the investing space. Thank you, and I yield back.
Thank you.
Gentleman yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Steil, for 5 minutes.
Thank you very much, Madam Chair. Thank you for being here with us, Director. Your economic analysis for the investment company's names rules predicted that the rule would impact over 10,000 funds in cost between $50,000 and $500,000 per fund. So if you do kind of the simple analysis and map that out, it's going to cost somewhere between $500 million and $5 billion. Some commentators even think it'll cost more than that. It's a pretty big delta. So I think about if you went to a car, you wanted to get your car repaired, and the mechanic came back and said it was going to cost between $500 and $5,000, I'd probably go find a different mechanic. Do you think that delta is a conflict in your ability to analyze the economic analysis and whether or not the rule is set out is net beneficial?
Sir, on the economic analyses, I would defer to my colleagues in the Division of Economic and Risk Analysis. They produce our economic. Sure,
no, I'm not asking you to comment. I'm taking the numbers on the surface. I'm just saying when you look as to the rule, whether or not it is on net beneficial, when you have that large of an economic delta, does that cause you concern or no?
I believe our colleagues are doing the best they can with the available information. I think it's enough information for the commissioners to make their own reasoned judgment on the proposal.
Appreciate your comment. I respectfully disagree. Let me jump. I want to flag an issue involving business development companies and co-investments. In February last year, Congresswoman Gwen Moore and I wrote to Chairman Gensler encouraging the Commission to make exemptive relief permanent for certain types of co-investments involving business development and their affiliates. And I'd like to ask for unanimous consent to enter the February record into the letter into the record. I assume it's so ordered, Madam Chair? Unanimous consent?
Yes, so ordered.
No, sorry, buried in my remarks. But I want to thank the SEC for listening to our concerns and making the changes we requested. I just want to refocus on the need to modernize the co-investment process involving BDCs. The current patchwork of individually granted, highly technical and confusing exemptive orders involving co-investment unnecessarily limits the growth in the BDC sector. And I would look for you to commit to working with my office on this issue.
Certainly, I'm very happy to do that, Congressman.
Let me shift gears to one final point. In a speech last summer, you said the following. It's a little bit of a long quote, but bear with me. You said, investor voices are being entirely delegated and used indirectly to influence portfolio companies' behavior without investors' awareness, attention, or perhaps even interest. Continuing the quote, if we take a step back and consider the size of the $30 trillion fund industry, that absence of democratic participation is certainly a noteworthy phenomenon. You're continuing, I see proxy voting as one of the main areas where markets could aim for increased democratization, which would, in turn, promote markets that more fairly reflect the views and priorities of American investors, not just large asset managers, end quote. I've made many of the same points in support of Chairman Clayton's 2020 proxy reforms and in support of my legislation on this issue. The 2020 reforms were designed to address problems that have been present in the proxy advisor industry for years, in my opinion, namely a lack of transparency and to methodologies, in conflict of interest and unreliable proxy advisor recommendations. Members of Congress on both sides of the aisle have raised concerns on this, yet under Chairman Gensler, the SEC reversed many of the 2020 proxy advisor reforms. Do you share the same concern that were targeted in the 2020 reforms regarding transparency and recommendation quality?
Sir, as you noted, this is a topic that I think is extremely important. I think what's helpful from our division's perspective is that investment advisors, including the asset managers who are charged with making those proxy votes, have a fundamental fiduciary duty, no matter what advice they receive, to honor that fiduciary duty when they cast their votes.
So let me build on that then. So if we look at whether or not a proxy advisor should be registered with the SEC, ISS is registered with the SEC as an investment advisor. Others, such as Glass Lewis, is not. Do you, in your opinion, should all proxy advisors register with the SEC? And should there be a consistent regulatory framework for this industry?
Certainly, there should be a consistent regulatory framework for the registration of investment advisors. With respect to any individual registrants, there could be differences that lead to circumstances and facts that lead to different outcomes.
Appreciate that. Are you supportive of Chairman Gensler's revoking of the 2020 Clayton proxy advisor rule?
Sir, I believe that was conducted through the Division of Corporation Finance.
Do you support that decision?
I would need to learn more about it specifically to make my own conclusion. Again, I think
Fair
that
enough.
was done by...
I appreciate you being here. Appreciate your testimony, Madam Chair. I yield
Gentleman,
back.
time's expired. The chair now recognizes the gentleman from New Jersey, Mr. Gottheimer, for
Thank
5
you.
minutes.
Thank you, Madam Chairwoman. Director, I sent you a letter with Rep. Sessions on June 15th asking for an extension of no action letter for broker-dealers accepting bundled payments for research and trading services. I understand that the expiration has in fact caused U.S. broker-dealers, including my constituents at regional firms in New Jersey, to lose access to research. Just wondering if you had received my letter. I never heard back from you, and I have a copy. If at some point you would answer us, that would be great.
Certainly, sir. I don't have a copy of that letter with me, but we have received a number of comments and have had extensive conversations with, I presume, a number of your constituents about that no action position.
Terrific. I'd be very grateful if you can get back to me this week. I'd be really grateful. It just goes back to
Make a
June.
point of it.
Thank you so much. And I'll make sure we get a copy and submit it to the record.
So ordered.
Thank you so much. And just on that point, is the SEC taking any steps to evaluate the impact of the expiration of the no action letter on the market for and access to research provided by U.S. broker-dealers? And can you talk a little bit about that?
I'd be happy to, sir. Yes, we have a number of ongoing and extensive conversations with particularly trade associations, but also specific broker-dealers that create the research and asset managers that consume it. We had a number of those conversations over the course of the last 14 to 16 months, and we continue to speak with them. We are aware of at least 3 ways in which firms can accommodate the expiration of the relief, such as by registering as broker-dealers, by offering the research through European affiliates or other affiliates, or by participating in collective sharing agreements with asset managers. But we are in constant conversations with the industry to evaluate what the circumstances are.
Thank you. Technology, as you know, is helping make financial markets more transparent than ever before, giving millions of Americans 24/7 access to data and insights. I appreciate the SEC's recent efforts to assess the risks of emerging technologies, but I'm concerned that the rule is so broad that it could unintentionally prevent consumers, like many of my constituents in New Jersey, from using technology to communicate with their advisors. Director, has the SEC studied the impact of the predictive data analytics proposal on consumer transparency and access to investment data? Can people text and email with their financial advisors? Like, it seems like I'm worried about it. It's just so broad.
I appreciate your concern with the scope, Congressman. The comment period for that release that proposal is still open. We are getting a number of comments about scope. The terms of the proposed release itself relate only to investment advisors using particular kinds of technology that put their interests ahead of investors. So in that sense, the scope is not unlimited, but I take your point that the scope ought to be an area of focus.
Right. Should people be able to even just text and email with their financial advisor without it being swept into that scope?
Exactly. It's a good question. Again, the release would speak primarily to whether or not that communication put the interests of the advisor ahead of the clients.
But that could be that's a pretty ambiguous measure.
Well, Again, part of the process of moving from a proposal to an adoption is to benefit from feedback such as yours and your constituents so that we can understand.
So speaking of that, when Chairman Gensler was before this committee in April, I raised concerns about the highly unusual short nature of SEC comment periods. I understand there's been a request to extend the comment period on this proposal for an additional 60 days, which might allow for more comments to be brought in, given the concerns that many of us have raised. As you know, engagement with regulated parties is essential to producing effective oversight and regulation. Is the SEC open to granting the extension to allow for more informed rulemaking, given how complicated this is, or does it prefer to just jam the American public?
Sir, I can't speak for the commission itself, but with respect to our division, we regularly meet well beyond the comment period with anyone who is interested in having.
Well, not really, right? I mean, the SEC in the last couple of years has really put a lot of short timetables and turnaround on comment periods, unusually short comment periods that are often simultaneous and don't give people enough time, stakeholders, to provide feedback to what might be very good ideas.
I believe the average comment length period in recent years has been 70 days, but my point is more to suggest to you, sir, that even if that official comment period closes, we read and receive and indeed interpret comment letters and take meetings well outside that comment period.
And you allow for that in the rulemaking?
Indeed, we do. Even in our recent rulemaking on private fund advisors, I believe a comment letter was cited that had been given to the commission just weeks.
So then why not just extend the comment period instead of having people go outside the comment period and allow people to have more feedback, which I think makes for better oversight and regulation?
Again, a decision of that kind, sir, would have to be made by the commission.
Got it. Well, if you can share our thoughts on that, that'd be very helpful, and I think constructive to making better processes when you have more transparency and openness.
I certainly will.
Thank you so much. I yield back.
Gentlemen, time's expired. The chair now recognizes the gentleman from Iowa, Mr. Nunn, for 5 minutes.
Thank you, Madam Chairman. Director Thistle, my state of Iowa has over 400 life insurance companies investing over $66 billion just in our local economy. These companies vary in size from a Fortune 500 company down to very small firms on Main Street, Iowa. My concern here today, and I want to echo what Congressman Gottheimer highlighted here, is that the SEC is moving out in a way that may not be fully vetting some of the rules that are coming out. And so I appreciate you being here today to talk with us on this. I want to specifically talk to a proposed rule that was released on July 26 here that conflicts with interest regarding predictive data analytics. Under the guise of protecting investors, it moves from AI, artificial intelligence, machine learning, quantum computing, with a definition that is incredibly broad. It includes the covering of all transactions, essentially every bit of technology that's been around since the 1980s, including Excel spreadsheets and calculators. In fact, in his dissent, the SEC Commissioner Ulati points out that even non-electronic calculators like an abacus might be legally subject to the scope of the SEC review. So, Director, I just want to ask a candid question here. Are we asking our advisors to go back to doing calculations by hand because calculators would now be covered by this?
No, sir. In fact, no technology is prohibited by this rule. The rule simply says that for investment advisors that do use the particular kinds of technologies that you alluded to in their interactions with clients, if they put their interests first, they need to remediate that.
So it would have the SEC reviewing these bits of technology. Let me ask, what things would not be under the SEC's purview in this covered technology? Could you give me a couple examples?
I believe Ranking Member Sherman may have alluded to an example or two earlier about credit card applications and so forth. The release states a number, but your point is really well made, sir, because this is the period of time, and the comment period on this is actually actively open, where we, and certainly my colleagues and the staff, will benefit from hearing concerns about the scope.
Consider that our feedback from Iowa. I appreciate that, Dr.
Received.
Birdthistle. I also want to talk about in order for a firm to be compliant with the broad and prescriptive requirements put forth in this proposal, firms would likely have to have a ton of additional personnel and take on substantial costs in order to regularly review every piece of technology they're bringing in. Again, I'm talking about my mid and small guys. When proposing a rulemaking with such vast consequences, did the SEC fully take into account the potential exorbitant effects this would have just on the costs of a medium or small business to be compliant with this?
Yes, sir. The economic analysis for this proposal, and indeed for all of them, does take that into account. Also, our staff regularly meets with trade associations and small investment advisors to attempt to understand as best we can their particular concerns on this and other releases.
And does the SEC fully appreciate then that providing these additional burdens on a smaller medium business is going to slow their innovation process, potentially giving a market advantage to a much larger corporation?
Sir, I can't speak for the commission as a whole, but certainly the members of the Division of Investment Management appreciate those concerns and take them very seriously.
Doctor, as you know, many financial institutions have a unique affiliate relationship. I've heard from one company in my district that has concerns this rule would prevent transactions between affiliated institutions, or do you think such activities are outside the scope of your review?
It's an excellent question, sir. I would need to, I think, understand the facts of your constituent a little bit more clearly, but I welcome them, and if it may be of use, I could work with your staff to help understand that particular circumstance. But generally speaking, yes, we are very concerned and paying close attention to the scope.
And as we've heard from some of our other colleagues, what would be a general timeline for a response on something like that? From your office to mine.
Be available to meet with you at your convenience, sir.
All right, fantastic. I'll take you up on that. I'd like to submit for the record, Madam Chair, a comment letter signed by 16 trade groups that together manage trillions of dollars in American citizens' assets, and request additional time to comment on that, as the SEC has not performed a thorough cost-benefit analysis of this rulemaking. And Dr. Birdwell, while I appreciate your willingness to meet with us, we also need answers back in writing to actually make good policy up here. Further, the letter highlights the fundamental misunderstanding of how firms rely upon technology in a myriad of ways to benefit the end investor and make sure that small and medium businesses are not disenfranchised by this. With that, Madam Chair, I yield back the remainder of my time, and I thank the witness.
So ordered. The gentleman yields back. The chair now recognizes the gentlewoman from California, Mrs. Waters, who is also the ranking member of our full Financial Services Committee.
Thank you, Madam Chair. Director Birdthistle, there are many examples of private funds executives or the investment advisors serving them charging junk fees to the investors. For one example, the SEC settled an enforcement case against a large private equity firm that was charging over $17 million in made-up fees. In another example, an advisor charged over $2 million in fees under the line item of compensated related expenses that were never justified or explained to the investor. Critics of this rule have claimed that the cost of complying with the rule will be passed on to investors, but I think it's clear that investors are already paying the price of a lack of transparency now. They just don't have the benefit of an itemized receipt to show that they're paying these junk fees. Could you discuss how the newly approved rule would help everyday Americans keep their hard-earned money instead of enriching already rich Wall Street middlemen?
Thank you very much for your interest on that topic, Ranking Member Waters. The Commission did adopt final rules on private fund advisors just a few weeks ago. Two of the particular provisions of that rule may be of particular interest to you. The first is one that requires advisors to private funds to provide to each of their investors quarterly reports on the fees they're paying and the performance they're receiving. Similarly, a second provision calls upon those private fund advisors to commission an audit of each of their private funds at least once a year. Those are two ways in which additional transparency should lead to better competition in the marketplace, and better competition means more money in the pockets of the pension funds and other investors in those funds.
How would you describe transparency? Is it a receipt? What should happen that would make the fees more transparent?
The quarterly reports will have to be consistent, and they'll have to state explicitly what those fees are, and that will mean that the investors in those funds will see what they're paying in any particular fund, and will allow them to compare with others as well, so that they'll be able to have better information for the bargaining and the competition of that marketplace.
So when one could or would take a look at the fees, even if they were transparent, are all of the fees lawful? Or can they basically make up fees that they could basically deem to be needed or credible? What determines whether it's lawful or unlawful?
No, it's an excellent question. And the release that accompanies that adopting rule talks a great deal about what kinds of activities by advisors are inconsistent with their fiduciary duties. And for instance, charging fees for unperformed services is an area of concern. So parts of that adopting rule do get at the point that you're raising.
What kind of penalties should we have for those who continue?
On that, I would defer to the commission itself and to the members of our Division of Enforcement.
Is it a matter of simply having to pay back, or should they be fines?
Again, that's an excellent question. I think the commission, when it rules on enforcement proceedings, also contemplates the size of penalties and the appropriateness of penalties. Our colleagues in the Division of Enforcement typically make those recommendations to the commissioners.
So given that you have such knowledge in this area, would you have any advice?
On what particular question, ma'am? I'm sorry.
No advice?
I wouldn't presume to tell my enforcement colleagues or certainly the commissioners how to do their jobs. I think they have extensive experience, but I do think that the rule being adopted, again, just a few weeks ago, creates an extremely helpful environment for a very large marketplace, but also the beneficiaries that you alluded to in your question. In many of these cases, the largest investors are pension funds, and that means they're representing the life savings of firefighters, school teachers, public employees. So to the extent that that marketplace is more competitive because of increased transparency, that is a benefit to average Americans.
Well, finally, you would agree that the bill is needed?
Pardon me, that
That the bill that is being proposed to deal with these junk fees, et cetera, is needed?
I am not in a position to comment on specific legislation, but I'm very happy to offer my colleagues to provide any technical assistance on any bills that are currently pending.
Thank you very much. I yield back the balance of my time.
Thank you.
Gentlelady yields back. The chair now recognizes the gentlewoman from Indiana, Mrs. Houchin, for 5 minutes.
Thank you, Chairwoman Wagner, Ranking Member Sherman, and thank you, Director Birdthistle, for your testimony and speaking with us today. When I joined this committee, and this subcommittee in particular, I promised to be a voice for everyday investors and fight for Americans across the country to have a variety of options and opportunities to build wealth and secure their financial futures. As my colleagues have highlighted, the SEC's numerous rulemaking proposals have implications that are far-reaching and would harshly impact retail investors, companies, and the investment industry alike. Under Chair Gensler, we've seen a concerted effort to crack down on innovation and reduce choice for investors, from rules that would impact the basic function of mutual funds to overly burdensome disclosure requirements. It seems as though the SEC is trying to quash growth and drive investment overseas. Director Birdthistle, during his testimony before the Senate Banking Committee last week, Chairman Gensler was asked about the SEC's rationale for proposing its open-end funds rule. The sole justification he mentioned was the market volatility observed in March of 2021 at the onset of the COVID-19 pandemic. While the proposed release alludes to concerns regarding dilution, it does not provide evidence of any funds actually encountering problems during this period. Is it accurate to assert that the SEC's proposed fundamental changes to the regulation of open-end funds and the process through which investors buy and sell mutual funds are primarily based on a few weeks of market volatility in the spring of 2020?
I believe those weeks were certainly important, Congresswoman, but the overall impetus behind that rulemaking is broader. It's to ensure that at any time that an investor redeems their shares and asks for their money out, that the fund is sufficiently liquid that it can provide that money to them. So certainly the incidents of March 2020 were a particular moment of that, but there have been other moments of stress too. But generally speaking, the rule is trying to make sure that at any time the promise of open-end funds is honored and people get their money out expeditiously.
It certainly appears to me that these changes aren't grounded in data, but rather speculative hypothesis. Is it your opinion that financial regulators should be guided by data or hypothetical speculation?
I certainly believe that our work is made its best when it is a combination of all relevant factors, including comments from constituents and data. The economic analysis in that release—
The question, though, sir, to reclaim my time, is should regulators be guided by data or speculation?
Certainly data is preferable to speculation.
Thank you. Director Birdthistle, as you're aware, the SEC has proposed or finalized 47 substantive rulemakings since Chair Gensler entered office. Many of these rulemakings have the potential to fundamentally alter many aspects of our capital markets on their own. Together, their collective impact is even more dramatic. Can you tell me where I can go to find the SEC's holistic review of these proposals and the detailed analysis of their cumulative effect on capital markets?
Madam, I can speak only to the rules that are produced by our division in investment management, but each of our releases, whether a proposed release or certainly an adopting release, contains an economic analysis that takes account of the world as it is at the moment that the release or the rule is adopted. To the extent that there are additional rules that have been proposed, those too will be contemplated.
Has the SEC done a holistic review of what the proposals will have in terms of a cumulative effect on the markets? Have they done it, yes or no?
I can't speak for the commission, ma'am, but
So
again,
you don't have any idea what the cumulative effect of all these rules going into effect would be. The rules have the potential to fundamentally reshape American markets, and you don't know or haven't done any analysis on the impact of what these will do to retail investors, pension plans, 401ks, or mutual fund investors? Do you think that's a responsible way to regulate our markets?
we take those interactions very seriously, and we actually look very closely with each of our rulemakings to evaluate how they affect the world as it is.
So our capital markets are deeply interconnected. What happens in one industry or sector of our markets often impacts the others, as I'm sure you know. Therefore, the rules governing our markets usually reflect that complexity and require the same care and caution. For this reason, many prior commissions have conducted roundtables, hearings, industry events to determine the true consequences of rules or better understand the nuances in each industry. Would you say that the rules your division has proposed and finalized are complex and could potentially impact millions of Americans?
I'm sorry, would I say that the rules...
Would you say that the rules that you've proposed and finalized are complex and could potentially impact millions of Americans?
I think the rules that we've proposed are well suited to the particular problems that we're trying to address in each...
Have you conducted any roundtables
We
or
extensively...
hearings?
I'm not sure our division has the authority to conduct a hearing, but we have regular conversations with our investment advisory.
Gentlelady's time has expired.
Madam Chair, just to close out this conversation, this feels a whole lot like Big Brother government trying to decide what's best, and I feel it is terrible for our
Gentlelady's
retail
time has
investors. I yield back.
The chair now recognizes the gentleman from North Carolina, Mr. Nickel, for 5 minutes.
Thank you, Chairwoman Wagner and Ranking Member Sherman. Director Birdthistle, welcome. The SEC's predictive data analytics proposal appears to lay the foundation for a broad change to the existing regulatory regime under which covered firms communicate with investors. The SEC's stated rationale is to eliminate the risk of investor harm resulting from conflicts of interest between financial institutions and their clients when working with AI, which is a problem we absolutely need to address. However, the proposal is very broad and offers a set of requirements that are loosely defined and cover most commercially motivated interactions between registered investor advisors and investors. I'm concerned that the proposed rule could stifle innovation and stop the technological deployment that's creating avenues of access and choice for traditionally underserved communities. Tens of millions of retail investors now participate in the stock market at extremely low costs, and we can't risk losing that. Does the SEC have evidence of widespread intentional misuse of technology that would create conflicts of interest that could not be addressed by existing regulations like Reg Best Interest?
Sir, as we produced the proposal that you just mentioned, and I should note again, the comment period for that is open, so concerns such as yours about scope are very important and ones that we're taking seriously. There are a number of incidences that our enforcement division regularly brings and circumstances in which investment advisors have put their own interest ahead of clients, and that's a perennial concern.
As it's currently written, do you believe that the proposed predictive data analytics rule encompasses all computational tools, not just AI and machine learning?
Sir, I believe the scope of the rule is restricted to investment advisors who use technology, and I believe you mentioned a few, machine learning, artificial intelligence, predictive data analytics, in communication with investors that puts their interest ahead of the investors. So in that sense, I think the scope is cabined, but again, I appreciate your concerns about scope. We're looking very closely at that issue.
I understand the SEC is behind on creating a specific registration form for registered index-linked annuities, or RILAs, as required by Congress by June 2023. Do you have an update on when we should expect the final form?
Sir, I know the form that you're talking about. We've been working on it diligently and expeditiously since Congress gave us that instruction at the end of last year. The form is due in the summer of 2024. We are working apace to meet that schedule and have actually been doing a great deal of work. The work falls on two divisions. One is ours, the Division of Investment Management, and we have been working on the rulemaking proper. The additional component that Congress required with its legislation was for there to be investor testing. That's conducted by a different division. They have been, I think both of our divisions have been working expeditiously to get that RILA's form produced on time.
As you know, the intent in passing the RILA Act was to put these products on par with other insurance products registered with the SEC, allowing the use of statutory accounting as insurers are permitted to do in other SEC filings. It's critical to that effort. I've got one more, but I don't think we're going to get to it. Thank you, Madam Chair. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from New York, Mr. Lawler, for 5 minutes.
Thank you, Madam Chair, and thank you to my colleague, Mr. Sessions. Director Birdthistle, the Commission's predictive data analytics proposal would apply to any communication by a broker-dealer or investment advisor to an investor client, whether those communications are individualized recommendations or not. This proposal could force smaller firms to forego innovative technologies to the detriment of investors. Broker-dealers must act in the quote-unquote best interest of their clients, and investment advisors are bound by statutory fiduciary duties. However, if an investment advisor chooses not to utilize certain technologies for fear of potentially running afoul of this proposal, wouldn't that investment advisor be violating its fiduciary duties owed to this client if that technology would actually benefit the client, such as by reducing costs or providing the client with better or more accurate information?
Sir, I believe the proposal to which you're referring was drafted in such a way as to harmonize it with previous guidance from the division on the fiduciary duty. So I don't think there'd be a conflict there. But as I mentioned to your colleague earlier, that comment period is currently open and active. So it's an excellent question, and we can include that in our comments as we're producing a recommendation to the Commission for adoption.
Well, in keeping with that line of thought then, in your view, to the extent that an SEC rule conflicts with an advisor's statutory fiduciary duty, which one trumps the other?
Congressional statutes always trump agency rulemaking, sir.
If an advisor is prohibited from acting in the best interests of its client because of an SEC rule, should the advisor follow the statute or the SEC rule?
Sir, agency rulemaking is subordinate to Congress and its statutory authority.
Okay, so they should follow the statute and not the SEC rule if it is in conflict.
I wouldn't presume to give them advice as their attorney, but yes, statutes trump our regulatory. We try very hard to make sure that they align as best as we can.
Now, following up on Mr. Hill's questions earlier, you couldn't provide us with a few specific examples of what the SEC would not be consider to be a covered technology. Have you had time to think about maybe some examples?
I would point to the release, sir. I think the release has a more precise and accurate list of those items. But if your point more generally is that we need to enhance the proposal so that it includes more of those, that's a very helpful comment, and we can take it as we're moving forward with that.
The rules requirements are excessively burdensome, in my view, and in some cases completely unworkable. Are you concerned that the rule and the burdens it imposes on broker-dealers and investment advisors might discourage these firms from potentially adopting the cutting-edge technology, as I talked about earlier?
The release itself, the proposal, does not prohibit any kind of technology by itself. To the extent that you're suggesting that the costs and benefits need to be fully appreciated, I agree with you. I think our economic analyses try very hard to compass the costs and benefits so that the commissioners can make a reasoned determination.
Okay. Madam Chair, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from New York, Mr. Meeks, for 5 minutes.
Bill included language that strongly encouraged the commission to take another look at the economic analysis in the proposal to ensure the analysis adequately considered the disparate impact on emerging minority and women-owned asset management firms. It's not working. The women-owned asset management firms, minority and women-owned businesses, and historically underinvested communities. While I didn't receive confirmation that a new economic analysis would be conducted, Dr. Wagner assured me that the SEC shared my concerns and was carefully considering the impact to minority and women-owned firms. So, with that assurance in mind, I'd like to read from page 553 of the Adopt and Release of the Rules, which states, some commenters also expressed concerns that the loss of smaller advisors would result in reduced diversity of investment advisors based on an assertion that most women and minority-owned advisors are smaller and associated with first-time funds. The commenters' concerns are consistent with industry literature. And then it goes on to say, to the extent compliance costs or other effects of the rules cause certain smaller advisors to exit, the rules may result in reduced diversity of investment advisors. That seems very important and very significant to me. And yet the impacts get even more severe on page 554, saying the potential reduced diversity of investment advisors may also have downstream effects on entrepreneurial diversity, as minority-owned venture capital and buyout funds are 3 to 4 times more likely to fund minority entrepreneurs in the portfolio companies. So, Director Birdthistle, can you respond to the anticipated impact the rule will have on diversity of advisors?
Well, sir, your comments were taken very seriously when you spoke with Director Wagner, and as you noted, the economic analysis was expanded and adapted to your concerns. The overall economic analysis, I believe, was about 250 pages or more, and that's an important component of it. With respect to the overall growth of the industry, I would note, as I mentioned in my testimony, the size of the investment advisor industry right now is then at an all-time high of more than 15,000 registered investment advisors with the SEC. The majority of those are smaller-owned investment advisors. And so I would hope that notwithstanding those potential concerns noted in the economic analysis, that the rulemaking as it is implemented will not have any negative impacts in your areas of concern.
Well, you know, because it goes on to say, how about the downstream effects that it will for minority entrepreneurs?
Certainly. Again, that's a projection being made by our economists in the Division of Economic and Risk Analysis, and it's certainly an area of concern. One thing I can say to you, sir, is that we meet regularly with investment advisors, particularly smaller investment advisors. We've had meetings with minority and women-owned investment advisors, and we take those concerns very seriously in this space and our future.
Yeah, but how about then smaller firms exiting? Wouldn't that have an impact on competition in the industry?
It could, although I believe there may be other areas of the economic analysis that talk to the potential attraction of other firms coming into this space, so that some may depart, others may enter. The private fund space is also at an all-time high, so the number of advisors is growing, the number of dollars in private funds is also growing. So I suspect there is opportunity there too.
I see I'm out of time. Thank you.
Thank you, sir.
Back.
Gentleman yields back. The chair now recognizes the gentleman from Texas, Mr. Sessions, for 5 minutes.
Madam Chairman, thank you very much, and thank you for holding this hearing today. I think that the director, Mr. Birdthistle, can see that there's widespread agreement that a discussion needed to take place, if not today, certainly around this time. Mr. Birdthistle, I was a little surprised when Mr. Gottheimer asked about the letter that he and I authored. You've now been provided with a copy of that. Is that the first time you've seen this letter?
I apologize, sir. It's possible that I did see it, and I certainly apologize for not having given you a more expeditious reply.
You mean no reply?
Again, if it is failed
Well,
to...
we on this committee do respect the job that you have. But with that respect comes an opportunity that we believe we're lacking with literally your whole department from the chairman down. You show up and give a nice conversation with us and say you're meeting with groups, you say that you're listening to people, and then when it nets out, as the gentleman, Mr. Meeks, presented about the loss of people, you talked about, but overall gain. I would say to you that this committee is very active, not just under the leadership of the gentleman from North Carolina, but also our subcommittee chairman, who are attempting to look at what is not statutory, but your mission statement to build within this country a framework of investment and opportunity for all Americans. And we try and provide you information, and I was a little surprised. So, Madam Chairman, I'd like to enter in the record Coalition Greenwich, a letter here that details hard dollar dilemma for U.S. brokers and investors as a result of the no action letter that we were thrust into from the EU.
Without objection.
And it is overwhelmingly a part of the industry. I didn't say you have to agree with the industry. I didn't say you have to be a watchdog over every action, but you do need to be consultative of them, and they overwhelmingly felt like that the challenge is more likely being felt by smaller and regional firms who lack European operations rather than the largest Wall Street banks who are expected to meet the deadline. Well, that would raise the question in my mind when we wrote the letter providing feedback from Congress so that we could get in line with not just the thinking that might be presented to us, but your thinking, and this was void. You didn't even take time to respond back to us. And so, Madam Chairman, I see a one-way street here. I see a one-way street where this administration, under the guidance of Mr. Gensler, shows up and puts a pretty face around whatever they want to. Meanwhile, they are hiding behind the notions that they're listening and trying to pay attention. And I find it repugnant that they have taken the views that they have about responding to members of Congress, that it's none of our business, that they would certainly engage with us about thinking about practices that we want to change in law, and yet they won't even engage us in the simplest of matters where we ask their opinion and present our information. Madam Chairman, I don't think that I'm always correct when I am visited by people from the industry. But I think that I try and balance that with a conversation with this administration. And when this administration fails on literally an issue that was a bipartisan letter, I could maybe understand they didn't want to respond back to me. I get that. But not even when we're attempting to work here in this committee chaired by Mr. McHenry and people like Ms. Wagner and Bill Huizenga, who are trying to work in a bipartisan fashion, hear from the industry, hear from the relationships on behalf of consumers, and we hear nothing back, and then they send someone up who just pretties it over and says, oh, we listen to people all the time, and then show up with no opinion and aren't willing to put something back to us in writing. I find that disappointing. So, Madam Chairman, thank you for your agreement to hold this hearing. I would like to have a better relationship with the Securities and
Gentleman's
Exchange
time has
Commission,
expired.
and I will yield back my time.
Gentleman yields. The chair now recognizes the gentleman from Missouri, Mr. Cleaver, for 5 minutes.
Thank you, Madam Chair, and Ranking Member for the hearing. Thank you for being here, Director Birdthistle. Whenever I come to these hearings, because I'm a little obsessed with housing, I'm always looking for something in here that either helps or hinders this very difficult task of creating affordable housing. And I grew up in public housing, which may be one of the reasons that I have this attitude. And so I believe that we design our homes, and eventually the home will design our lives. And so I really zeroed in on the fact that the SEC's safeguarding proposal could upend existing regulatory structures for certain physical assets, like real estate. And if you're requiring advisors with custody of each asset to maintain those assets with a qualified custodian, then I'm concerned about where that came from and what positive aspects would overshadow what I see as something a little troublesome.
It's an excellent question, Congressman. The safeguarding proposal generally is designed to ensure that when a client gives assets to an investment advisor, those assets are not lost, misused, or stolen, or misappropriated in any way. To your particular question about real estate, the proposal as it now stands, and that proposal has been reopened for comment through the end of October, it has an exception from the requirement that those assets be kept with a qualified custodian for physical assets, including real estate. So certainly we're in a position right now also where we can take direct comment on whether or not the scope of that release makes sense as applied to real estate.
But you've included mortgages and deeds. I mean, are you saying here that this is something that you're just simply testing and think about, or are you saying that you think this does no damage to our effort to encourage people to get mortgages? 7.2% interest right now is a discouragement. I'm trying to make sure that we do nothing to interfere with people getting homes.
I fully appreciate that concern, sir. Again, the release would apply only to people who give that asset to their investment advisors, which I think is relatively unusual with respect to real estate. But more to the point, the scope of the release is one that the staff is looking at actively as we move towards a recommendation for the adoption to the commissioners. So your concerns are well taken and ones that we will look at extremely seriously as we move forward.
I appreciate that. But as I just mentioned, 7.2, we don't know which way it's going to go if there's another increase. But right now, the interest rates and the low office occupancy in Kansas City, Missouri, probably the same as my colleague, the chairwoman, in St. Louis. So the real estate market is paying a lot of attention to the impact of these rules and regulations. Can you tell me the projected impact of this rule on commercial real estate markets, or is it the same?
Again, physical assets are specifically excluded from the need to keep any assets with qualified custodians.
Commercial or?
They would be out of that portion. They may be within the overall scope of the release, but they would be exempted from the qualified custodian portion. But again, even their presence in the scope is something that we can consider more directly, given your concerns.
Thank you. Thank you, Madam Chair.
Gentleman yields back. The chair now recognizes the gentleman from Michigan, Mr. Huizinga, the chairman of the Oversight and Investigations Committee, for 5 minutes.
Thank you, Madam Chair. Director Birdthistle, what do you do?
Chairman, I'm the director of the Division of Investment Management at
That doesn't tell me what you do. That tells me your title. What do you do?
I work with my colleagues in the Division of Investment Management to work on reviews of filings that are made for funds that want to go effective in our country, to analyze the market data that affects those funds, advisors and investors. We work on rulemaking, as we've discussed in much of this hearing. And we also have a chief counsel's office that I oversee that makes exemptions for business participants who want relief from certain of those rules.
And any of the concerns that were expressed by my colleagues, Mr. Meeks, others, I mean, doesn't sound like you're taking into account, though, some feedback.
Actually, feedback is probably the most important part of what we do. The rulemaking office spends a great deal of time meeting, and I participate in those meetings.
Okay, and when do you fit that in? I mean, you're listed as a full-time professor as well, correct?
I'm on a leave of absence as a professor, sir, so I have not
Okay,
done...
so, but your school on the website still lists you as a full-time professor.
They may do so. I don't know what the website says, but I am on a leave of
Okay,
absence.
you might want to check in with them. So you're a full-time SEC employee?
I am, sir.
Okay. Could you share with us the structure of your pay agreement?
I am retained pursuant to an intergovernmental personnel agreement, which is a structure that I believe the government uses to move people around within government position to government position.
The IPA? Well, I'm familiar with the IPA.
Yes,
Those
sir.
are typically a temporary assignment. You're knocking on the door of 2 years. That doesn't sound very temporary to me. But could you still illuminate then what your pay is? So you get paid through the university.
That's correct, sir.
Okay. And you're aware, I'm assuming, being a good lawyer that you are, I'm assuming that you're aware of the letter from Chair Comer, the chair of the full Oversight Committee, specifically asking about your position with the IPA and what's been going on. So give me some more detail. Let's help them out. So I'd love to know what your contract is with the SEC, how long it's supposed to be going, what your pay scale is through the university.
Certainly, sir. So IPAs, I believe, run 1 year at a time. So I was signed up to an initial one in December of 2021.
So you're on your second. Are you planning on a third?
That's a decision for the chair of the agency and our Office of Human Resources, sir.
But do you want to do a third?
Sir, I serve at the pleasure of the commission, and that's a decision for them to make.
Got it. In your view, is 3 years temporary?
I'm not familiar with the particular terms of the IPA rules.
So being the good lawyer that you are again, do you believe that if you were taking this to court of law and someone was saying, well, it's only a temporary employee, but they're on a third consecutive contract of 1 year at a time, would you believe that that would be viewed as temporary?
Sir, I have no expertise in the area of human resources.
Oh, I think you got a lot of expertise. So is that temporary?
Sir, I really, first, I'm not on a third extension of.
No, not yet, not yet. We understand that. So, well, we'll see whether that third extension comes. So it seems like you're doing a lot of deferral to the commission, a lot of deferral to other folks. That's why I'm trying to figure out what you actually do, why you are so vital to this process that you're on your second full-year temporary contract, maybe headed towards a third. We'll see. So I guess we'll, in conjunction with Mr. Comer, we're going to help him sort that out. I do want to also explore a little bit. Do you agree that university endowments that are LPs and private funds stand to benefit from the private fund advisor rule?
I believe the entire marketplace will benefit.
But no, specifically do these university endowments?
I don't have a particular opinion.
Okay, so, and is it not true that Illinois Institute of Technology Endowment is in an LP, in a private fund?
I don't know that, sir.
You don't know your own retirement?
I have a 401k plan, but I don't know what the status of the endowment is. The endowment is usually not related to individual.
It sounds like this could be a conflict of interest. So my time has expired. We'll continue with some follow-up in writing. I yield back.
Yeah, the gentleman's time has expired. He yields back. We most certainly will follow up. The chair now recognizes the gentleman from New York, Mr. Garbarino, for 5 minutes.
Thank you, Madam Chair, and I yield to you.
Mr. Director Birdthistle, are you paid by the university on top of your SEC salary?
No, ma'am, I'm not. I am paid through the university by the agents.
Is this standard procedure?
I believe it is.
Well, we will certainly be doing some oversight. I understand that Chair Gensler is also paid by MIT in addition to his salary. Is that correct? Do you know?
I can't speak to the chairs.
We will speak to it. I thank you very much. I yield. I thank the gentleman for yielding.
Thank you. Director Birdthistle, the Commission's proposed liquidity risk management rule amendments for open-ended funds would in effect prohibit the operation of bank loan-focused mutual funds and ETFs and force existing funds in this asset class to liquidate. In light of the fact that open-end bank loan funds have an impeccable record of solid investment performance and offer retail investors diversification benefits in a macroeconomic environment punctuated by inflation and increased interest rates, and have never failed to timely meet even a single investor redemption request, has the SEC considered any alternatives to regulating these funds out of existence?
Sir, the release proposal does not suggest eliminating bank loan funds. Bank loan funds do have a longer settlement cycle than the typical period by which an open-end fund would need to redeem its shareholders' funds. But that's a choice that that sector could make, whether they wish to shorten their settlement cycle. But the release and the rule itself do not prohibit bank loan funds.
It doesn't prohibit, but do you believe that it will cause some of these to liquidate?
I don't know that, sir. It's possible that they would increase their settlement cycle. I believe that purchases and sales of bank loans are effectuated rapidly. The only lag comes from the fact that their settlement cycle extends into weeks.
If the SEC starts seeing that a bunch of these ETFs and mutual funds are starting to liquidate because of this rule, would they reconsider and pull back the rule?
I couldn't speak for the commission, sir.
Would you recommend to them to do that?
It would be very interesting to see how that dynamic unfolds. But again, the primary aim of the liquidity rule is to ensure that when investors redeem their shares, the funds are on hand to pay them that money.
The SEC has the SEC conducted an economic analysis regarding the impact that eliminating open-end bank loan funds will have on capital formation and borrowing costs for companies that finance themselves in the syndicated bank loan market, or the impact that simultaneous forced selling by these funds could have on the market and other investors in it?
Yes, sir. The economic analysis for the liquidity proposal is approximately 130 pages long, and I believe it touches on that and other costs and benefits as well.
So there has been an economic analysis done, cost benefit, and still the SEC feels that moving forward with this rule will not have a negative effect.
I can't speak for the commission, sir, but I believe they did have that economic analysis when they voted on the proposal.
So I'm guessing the economic analysis was not negative?
Economic analyses, again, they're produced by our colleagues in the Division of Economic and Risk Analysis, but they set forth a range of costs and benefits, and then it's for the commissioners to evaluate, to make a final decision based on that.
Thank you. Director, Chair Wagner asked whether you would withdraw the open-end fund liquidity proposal based on the overwhelming and bipartisan criticism you have received. In response, you said you were reviewing this input. I want to follow up by asking this. Truly taking into account the robust and bipartisan criticisms of open-ended fund rule would involve making substantial changes to the proposal. In that case, the Administrative Procedure Act would require the SEC to repropose the rule. So can you pledge to this committee that you will advise the commission that it must withdraw and repropose the proposal? And if you don't significantly modify the proposal, then how would you justify ignoring the feedback, particularly given that there was no problem in March of 2020?
Sir, if the release were to change between proposal and adoption, the Administrative Procedures Act allows for a number of alternatives to be pursued, so long as those alternatives were laid out in the proposal and comments were solicited or received from the public. So there are ways in which releases do change between proposal and adoption that don't necessarily require reproposal. A decision on whether to repropose would be one that the Commission would make, but changes regularly do happen. In fact, I think in the majority of adoptions under this, for the agency in recent years, there have been adjustments between proposal and adoption.
But I believe from what we've heard that there be, from what we've seen bipartisan criticism, there'd be substantial changes which would require a reproposal. So I'm out of time, Madam Chair. I yield back.
Gentleman yields back. I'd like to thank our witness for his testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witness to the chair, and you will be receiving those, which will be forwarded to the witness for his response. I ask our witness to please respond as promptly as you're able. The hearing is adjourned.